make a presentation on the topic, the role of courts in intellectual property enforcement. My presentation is in PowerPoint. I sent it this afternoon.
Madam Judge,
Yes.
Madam Judge, are you comfortable speaking without the mask so that you're a bit more audible?
Not quite. Allow me to wear the mask because I tended to develop a cold this morning.
Oh, okay, sure.
My presentation has an outline, and the outline defines the terms, the categories of intellectual property. So can I proceed as you? All right. My presentation has an outline of the definition of the terms, the categories of intellectual property, the laws applicable, the works that are protected, what enforcement means. I've also indicated the challenges and the recommendations. The terms intellectual property, the fourth industrial revolution, and enforcement are defined. I will not read that since I have only about 8 minutes. Intellectual property, the categories I have indicated relate to trademarks, categorized as patents, industrial designs, scientific discoveries, literary, artistic, and scientific works, known as copyright, and then performance of performing artists, producers of phonograms and broadcasts, known as neighboring rights, and then protection against unfair competition and trade secrets. The laws applicable are therein stated. Protected works. In order for the various intellectual activities that I have mentioned above to be protected, those rights must be legally recognized by way of registration, and registration is only done when the formal requirements have been met by the applicant. Registration may be national, regional, or international. A trademark is defined. The formal requirements for a trademark to be eligible for registration are indicated therein. The rights that the owner of a trademark acquires upon registration are indicated therein. My interest for purposes of enforcement is infringement. Infringement of a trademark occurs when a person, not being the owner of the trademark or authorized by the owner of the trademark, uses the mark identical to or resembling it as to be likely to deceive or cause confusion in the course of trade in relation to any goods of the same description, where the use would result in a likelihood of confusion and in such a manner as to render the use of the mark likely to be taken as importing a reference to the same person having the right as owner or a registered user of the trademark or to the goods with which that person is connected in the course of trade. The test of infringement is indicated. The remedies available are also indicated. Copyright. It's defined, and the requirements for protection are that the work must be original and must be reduced in material form. There are cases that illustrate what an original form, what originality means, and what amounts to reduction in material form. They're indicated therein. I have further indicated that apart from the copyright owners getting protection, there are those that help the copyright owners to disseminate their works, and they acquire rights known as neighboring rights. They also have their own rights and deserve protection, and their rights are indicated therein. Infringement of copyright is deemed to occur where without a valid transfer, license, assignment, or other authorization under the Act, any person deals with a work or performance contrary to the permitted free use, and in particular, where that person does or causes or permits another person to do those acts. They're indicated therein. I've also looked at patents. My presentation has been focused on three areas. Patents, the requirements for registration of a patent, the rights that a patent owner acquires, and what amounts to infringement. Enforcement. Of course, enforcement of intellectual property rights, which I have discussed above, requires a concerted effort of the stakeholders, and for any person to claim infringement on intellectual property rights, that person must establish a cause of action, whereupon the court will grant an appropriate remedy. The role of the courts in the enforcement of intellectual property rights, as seen in the remedies granted by the courts, varies depending on the nature of the claim. And these cases will illustrate these remedies. In the case of Uganda Performing Rights Society Limited versus Fred Mukubira, I've taken into consideration the application arising from that suit. This is an application where the applicant was the sole assignee of copyrights in musical works of a Frigo band, and the respondent had infringed on the copyright upon which he had acquired rights of assignment, and he rushed to court, and his prayers were that he wanted the respondent, he wanted to be permitted to enter the premises of the respondent where the alleged infringement was carried on. And therefore, he wanted an Anton Pillar order. The judge in that case discussed the requirements for the grant of an Anton Pillar order, but what is most significant in this symposium is not the decision of the judge, but the remarks that the judge made in that ruling, where he said an Anton Pillar order is not a search warrant which entitles a holder to force his way into the defendant's premises against his will. The defendant, by the Anton Pillar order, is only enjoined by court to do permit the entry, inspection, or other direction of the court. And the order should be served on the respondent, attended by counsel for the applicant, who is and must strictly act as an officer of the court. The respondent must be given an opportunity to consider the order, and if necessary, consult his or her counsel. And if entry is refused, the applicant should not force his way in. The applicant, however, may bring the refusal to the notice of the court, and if need be, by an application to commit for contempt of court. The judge discussed the scope of the Anton Pillar order, which was granted, and made a remark that cases of this nature are, he actually fixed the main suit in a week's time after that ruling. As I evaluate this case, my comment is that, of course, cases of this nature are supposed to be fast-tracked in the court system, and the judge was well aware of that and made that order. However, with the huge statistics of cases in the system and the number of cases cause listed per judge, in the new normal, where we have a minimum of 4 cases cause listed, this approach may not be possible. And as my brother, the learned retired principal judge, indicated, there is likelihood of delay cases and therefore backlog. Taking into consideration the remedies that the remedy of Anton Pillar order that the judge granted to the applicant, we are talking about industrial revolution, the use of technology. Yes, technology can be used to create a virtual scene. And in the circumstance we are in now, is this possible for the orders of the court to be enforced in a virtual environment? That is food for thought. In another case of Stella Atal and Anne Abels Chiruta, trading as 97 Africa Arts and Crafts, the plaintiff had authored various artistic works, and the defendant approached her assistant. The defendant, who was one of the persons he used to distribute the products, then used the assistant to get information on how he could reproduce copyright works of the plaintiff. And indeed, he did reproduce counterfeit copies and made duplicate reproductions of the plaintiff's best-selling art pieces. When the plaintiff came to court, he sought for remedies of Anton Pillar order, an injunction, damages, and costs. The judge in that matter entered judgment in favor of the plaintiff against the defendant and awarded 5 million shillings in general damages, 5 million shillings in exemplary damages, and a permanent injunction restraining the defendant or her agents or servants from reproducing assembling and distributing artistic works of the plaintiff's copyright works, and destruction of the infringing works. Of course, as we know, many Ugandans are involved in the making of artistic works for a living, and indeed, this case illustrates the need for protection to enable them to reap big from their intellectual efforts and to promote further intellectual activities. I see I'm running out of time. Allow me to go straight into the challenges. The challenges of enforcing intellectual property rights in the fourth industrial revolution. To begin with, I have addressed my mind to these challenges, taking into consideration that the jurisdiction of most of these matters is High Court. And I will not delve into the challenges that we face as the judiciary in respect of the lower courts. One of the challenges, of course, is accessibility to infrastructure, and we have both the physical and digital infrastructure. If we are talking about technology, how many courts have regular supply of power? We have intermittent power supply, and even the digital structure is lacking in many courts. Not all courts have the digital infrastructure. We know government has a policy, a strategy on the fourth industrial revolution, but however, the transition of the implementation of this strategy varies across government departments, institutions, and agencies, and of course, judiciary being one of the institutions, this challenge is faced as well. We have lack of standardized application programming interfaces and common data languages for the increased integration of largely self-sufficient systems. We are talking of ease in communication, but for example, I can say, if I wanted to confirm if a party has paid fees, the cashier would have to log into the URA portal to get that information. And we are talking about use of technology. Why can't we have that information right into the judiciary system? And the cashier looks at that in the judiciary system other than going to the URA web portal. So those are the kind of things we have to address if we are talking about the fourth industrial revolution. We also have dangers of cyber attacks. We have communication costs, the use of internet bundles, airtime. Those are all challenges that may affect the enforcement of intellectual property. Remember that the intellectual property owners will need these facilities. And most times, some of them do not live in the major cities. The other challenge is also change of mindset. We have categories of people, right from the court users to the judicial officers. There are those who completely say that is for the .com era. So who is in the .com era and who is not in the .com era? As long as you're living and you're still breathing, you're in the .com era and you have to change. These are some of the recommendations. Of course, we know government has given support as a nation by having the national strategy on the fourth industrial revolution, which was adopted in October last year. We also have government support to the judiciary, in which we have now developed a new system known as ECMIS, Electronic Court Case Management Information System, which overcomes most of the challenges that we had with CAS. CAS was the previous system in which cases are registered in the judicial system. But because of the technological obsolescence of CAS, judiciary has now developed a new system of ECMIS. And ECMIS is intended to register the life cycle of a case, right from the time of filing to the time of archiving. And this involves e-filing, e-services. So we'll require change of mindset in that. We already have email addresses for most of the courts where the advocates submit their submissions, make their submissions online. And that is really a step ahead for us to cope with the aspects of the fourth industrial revolution. We also have the justice-wide integration, and this is work in progress for NITA-U. NITA-U is integrating the justice sector institutions so that their systems speak the same language. For example, if I'm going to grant bail and I want to know whether this person has a national ID to stand as a surety, it is just a matter of clicking on the NIRA system, and then I'll be able to see that this person is qualified to stand as a surety for this person and grant bail accordingly. So that is the kind of system we are talking about, systems talking to each other. We also have accelerating the physical connectivity of fiber optic networks, as well as the interoperability of virtual platforms. We want systems that are self-sustaining in itself, and also a system that understands the language of other systems. And that is what NITA-U is doing for the justice-wide sector integration. Of course, with ECMIS that judiciary has now introduced, there is need for a robust technical team to render technical support. We have the professional ICT staff, and they are up to the game. Judiciary has just been carrying out training on digital skills, the use of ECMIS. In 2 weeks' time, they had trained advocates. Law Society was involved. They've trained the judicial and non-judicial staff on digital skills. And in the ECMIS system, each user has a role, and depending on what your role is, the system will give you a notification. For example, I, as a judge, the moment I log in and get to my page, I'll find probably a notification there that this matter is pending ruling, or this matter is pending judgment. So that it acts as a bring-up system, and it reminds you, the judge or the judicial officer, to promote efficiency and effectiveness. And of course, it is also a system that is designed to reduce delays and backlog in the system. But of course, this, as I said earlier on, it requires a concerted effort of all the stakeholders. In that regard, the public will be required to be sensitized on how to file online, and that is where ECMIS is taking us. We have change management. This requires the whole institution, or the judiciary, to own up by bringing all the staff on board. And as I have told you, in 2 weeks, the last 2 weeks' time, the judiciary has trained all categories of staff, ranging from the judicial to the non-judicial staff. This marks the end of my presentation. Thank you.
Thank you very much. Thank you very much, Justice Sabinia. Please have a seat. So after listening from very experienced judiciary, I would now welcome Miriam Nabatanzi. I believe she's from the Ugandan Registration Service Board. A lot has been discussed by the two justices. Miriam, may I allow you 10 minutes to share your experiences from a regulator perspective?
Good afternoon to all the participants. I request to share my screen with you. Okay, so my name is Miriam Nabatanzi, and I'm happy to serve as the head of compliance and enforcement at URSB. I'll walk you through the role of Ugandan courts when it comes to enforcement of intellectual property rights. And here, I will restrict myself to our experience as far as criminal prosecutions are concerned, because we do not handle civil suits. These are usually actions between two parties. That is the rights holder as well as the infringer. So by way of outline, we'll have an introduction, then we'll delve into the role of courts from our experience as users. I'll give you a few examples of decided cases, and then briefly we'll touch on the challenges that we encounter. When it comes to our introduction, maybe I'll give you some bit of context that in 2019, the DPP delegated some of her prosecution powers to officers of URSB. So we have 5 advocates who handle criminal prosecutions. They basically prosecute offenses that arise out of the laws that are implemented by URSB. And the major subject matters when it comes to our IP enforcements have been counterfeiting and piracy of goods. Laws criminalize imitation. You've already heard about that from the land judges, but also reproduction of copyrighted works is forbidden. The legislation has also been touched upon. It's the Trademarks Act and the Copyright and Neighboring Rights Act. So infringement of patents is not criminal per se, so the rights holders need to pursue civil remedies. They need to go for civil action. When it comes to jurisdiction, oh, sorry, I went ahead of myself. So when it comes to jurisdiction, all our prosecutions are handled by the Standards, Utilities and Wildlife Court at Buganda Road. We don't have specialized IP courts in Uganda, as has already been mentioned, but the judicial officers there at Buganda Road, where our cases are diverted, they do have vast knowledge and experience in IP matters over time, and some have had specialized training. The prosecutors, of course, the practice now is to opt for prosecution-led investigations. So we also have an in-house police enforcement unit. It was created in 2016 by MOU with Uganda Police. So they help us with the investigations of those cases, and then the in-house prosecutorial team will take on the cases in the Standards, Utilities, and Wildlife Court at Buganda Road. I must say that from 2019 to date, we've prosecuted 66 cases. Some are still ongoing, and success has been registered in 35. They've managed to secure convictions, which is no mean feat. Now, as a user, we would expect the courts to do the following when it comes to enforcement of IP rights. Of course, their primary role really is to determine the truth based on the facts that have been presented before them. We as the prosecutors, we usually have to prove the ingredients of all the offenses with which the accused person has been charged, and would expect them to decide these cases in a speedy manner, but of course in all fairness. Now, when it comes to counterfeiting, the ingredients we usually have to prove is that there was a forgery of the trademark, there was intention on the part of the accused person to defraud the other persons, but also that fella did not have authorization from the trademark proprietor. This is a strict liability offense, so it does not matter whether you knew that what you are doing was wrong or was criminal in nature, as long as you're caught with counterfeit goods and you're prosecuted successfully, you should be able to have your sentence pronounced. When it comes to piracy, of course, we must prove that the person who reproduced the works did not have authorization from the copyright owner, and that that person did communicate the protected works to the public. This as well is also a strict liability case. Now, the other role we would expect the courts to play is to protect the rights of the IP owners. So where you find that sufficient evidence, we've proved beyond reasonable doubt that there was an offense committed, we would expect the accused persons to be convicted and appropriate punishment to be given to that person. But now in practice, there is need to balance the rights of the IP rights holder as well as those of the public. You will find that these cases, yes, there's always a complainant who is the rights holder, but these are cases brought by the state on behalf of the Ugandan people. So it's not enough to just look at how much profits were lost by the rights holder, but you also need to look at the gravity of the irreparable harm that members of the public have suffered. Many of the products that we impound and eventually tender into court as exhibits are also harmful for human consumption. We are talking about drinks, we are talking about consumables like sanitizers. We even have feeds, we have food, posho, we have medicines. So it's not enough to just say, I sentence you to compensate the rights holder. At least there must be a strong signal sent to infringers that this vice is not condoned as a state, because the damage they cause to the public may never be able to, may not be quantifiable in monetary terms. Then something else I would also expect the courts to help us on is the disposal of the exhibits or the counterfeiting items or the pirated goods. Usually when we conduct an enforcement of operation as a bureau, we do see some goods. Eventually we end up tendering them in court to prove our cases. So at the end of the day, we would expect to obtain an order instructing us to destroy, but the practice has not been uniform on who is supposed to handle the costs of the destruction. Sometimes it is the infringer, other times the judicial officer does not make a pronouncement, and I will share with you cases where the rights holders have actually had to bear the cost of destroying their goods. It is bad enough that they've suffered loss as a result of the unfair competition, but also you need to punish the infringer to the extent possible so that it acts as a deterrent. Now, there are also some statutory roles in the Trademarks Act as well as the Copyright and Neighboring Rights Act that have been given to the courts. Of course, the one that came to mind, although this is usually a civil action and URSB handles criminal actions primarily on behalf of the DPP, but I would expect that when an application is made to them, that they are infringing goods that are about to flow into channels of commerce, maybe through entry points, the border points, and the applicant has provided reasonable grounds to believe that a consignment is coming in and it has counterfeit products or it has pirated goods, they should be able to instruct our colleagues in customs, that is URA, to suspend the release of those goods until the matter has been disposed of in a court of law. Because we as a bureau find it very challenging to look for goods that are in circulation on the market. It's easier to get them when they are still in one central place, maybe at the border point, than to look for them if, for example, I'm looking for maybe toothpaste. It's not easy for me to look for it in all supermarkets, all small shops countrywide, but it's easier to seize a consignment before it enters the Ugandan market. I'll give you only two cases to illustrate what I'm talking about. Now, we had this case of Uganda versus Nampango Yusuf. It was basically about fake toner cartridges. HP was the registered brand owner. So we prosecuted the accused persons for falsely applying the registered trademark contrary to those sections. And it was actually a very big consignment. We are talking about toners that were valued at over 7 billion Uganda shillings. There were so many metric tanks. I think there were over 5 metric tanks. So to cut the long story short, he was sentenced to a fine. He wasn't even given a custodial sentence. So he was asked to pay 50 currency points, which is approximately 1 million. In default, he had to spend 2 years in prison. Naturally, he was able to pay the 1 million. It's also important to note that the maximum sentences also in our Trademarks Act are not very punitive in nature. For that particular offense, if you're found guilty, the highest amount you can pay is 2.4 million, which is 120 currency points, or imprisonment not exceeding 5 years. So you'll see that the damage is not commensurate with the punishment, because naturally any accused person would be able to settle that cost. But the issue of destruction, the judicial officer never made a pronouncement. Yes, they said have the goods destroyed, but the cost center were not advised on who was to bear the cost. Now, for these 5 metric tanks, you will find that the brand owner had to pay over 50 million Uganda shillings to have the same destroyed in Nakaso, Angola, which was, in our view, was something that could have been borne by the infringer. Then the other case I wanted to share with you, we have Uganda versus Ahabwe Amos. I picked out a drink so that it can we can all relate with it, because some of these goods, yes, they're also counterfeit in nature, but they also have standard issues. Now, these are alcoholic drinks that we consume. This person was also charged for the same offense. He was fined eventually. The beauty with this judgment is that he was also ordered to meet the cost of destroying over 249 cartons of the infringing drinks. So the issue of balancing the interests of the public vis-a-vis those of the rights holder came into play, because yes, you can say you want to compensate the brand owner, but how about the bigger society that may have consumed these drinks? Some of them pose serious health risks to them. So we also needed to have the rights of the public protected. I'll conclude by sharing with you some of our challenges. They are not very many. And our biggest challenge in the practice really has been that many rights continue to exist side by side without being registration. I mean, without being registered. And here I'm talking about copyright predominantly, because for the trademarks, we would only be able to take on a case if a complainant can prove that the right is registered and that you your trademark is renewed, if at all it is due for renewal. But copyright registration is optional, so you end up pursuing a criminal case and then issues of ownership arise. So we feel the ownership issue is best handled by the civil courts. So it kind of prolongs the litigation, and the criminal matter has to stall because we have to determine issues of ownership, who owns the right in a song, in a book, in a movie, things like that. The other issue I mentioned was the patent infringement is not criminal in nature. So you'll find that many of the rights holders have to sort out their issues in civil courts. And the most confusing for us really has been a pursuit of multiple remedies. Many a times rights holders choose so many routes to enforce their rights. So as you are taking on the civil matter, they will in parallel lodge a civil case. So what happens if the civil matter is going to stop the criminal case, or they will issue a judgment which is contrary to what is going on in the criminal courts? So there is need to have some kind of harmonization. Yes, there is no legal bar. You can pursue both remedies concurrently, but you'll find that one court may not necessarily, the decision in one court may not speak to the decision in another court. So in a nutshell, that is what I had to share with you.
Thank you very much, Miriam. It was very interesting finding out from Uganda that you, as the Uganda Registration Service Board, can act as prosecutors. So a lesson probably I should take back to Tanzania. We've heard from the judiciary, we've heard from the regulators. So now we'll hear from a fellow lawyer, a practicing advocate, Ms. Alice Blazovic. If you could sum up your experience in 10 minutes on the role of courts in the intellectual property enforcement. Alice? And Miriam, please stay on with us. We might be getting some questions, so you can answer those. Alice?
Thank you very much. Hope I'm very clear. Well, I've realized that I think both her worship and Miriam's presentation had, a lot that I had wanted to share, especially with the challenges and remedies. But for me, basically, what I wanted to bring to light is the glaring realities we have to deal with right now in the digital era, where we're in a situation whereby a click of a button, you're able to disseminate or come up with like thousands of copies of copyrighted work without so much, rather without like the enforcement arm doing, rather without the enforcement arm intervening. And why are we definitely in this situation is because we all know there has been like an increased usage of the internet. So many people now have access to like I would say digital platforms. So what 10 years ago, 20 years ago, what the courts were faced with is completely different now. Because right now, it just takes, like I said, a click of a button for things, for someone's copyright to be infringed, or for someone's design to be hacked. I think it's her lordship who talked about the challenges the judiciary is experiencing, which is cyber attacks. And the truth of the matter. Sorry, I think I was muted there. Somehow I got muted. Yeah, what I was trying to say that
Is Alice with us?
hello?
Yes, we can hear you,
Hello?
Alice.
Yeah, sorry. I think I got muted by the host somehow, but anyway, yeah, what I was trying to say is that the era we're in right now definitely poses different challenges, and we definitely need to equip our enforcement arm with new tools. I'm also glad that her lordship, when she was talking about right now, what the role of the courts, the challenge, some of the challenges, the role of the courts, and the challenges the judiciary is experiencing. I thought she was very how can I say, very honest, because from a practitioner's perspective, some of the things actually she mentioned are some of the frustrations that we are facing in the digital era. She talked about lack of infrastructure, lack of electronic systems that are able to connect the different, either government agencies, international agencies. All these things are definitely missing in the picture. But you somehow have to find a way of presenting your case with very, I guess, little infrastructure to connect you from the local regulatory, authorities to the international regulatory authority, regional regulatory authority, right from the registration process to, of course, the enforcement. And also, of course, one of the challenges that I personally experienced is that when you want to like most probably present evidence from the different registration regulatory authorities or registration systems, you find that because they're really, really interconnected, it's so you are constantly forced to always, go back and forth, trying to get information or evidence from one system to another. But where we are going and where we are right now, if we understand our realities, I'm sure definitely we can do so much. One would be whatever systems. I mean, it's always good to start with low-hanging fruits. So what kind of technologies do we have right now that we can be able, first of all, to deal with the challenges that we are facing right now? That is specifically with the judiciary, so to help it enhance the way it enforces IP rights. I always find that we have all these like simple or simplified digital tools, but I think our judiciary is just not usually they're always very quick to say, oh, we don't have this kind of system, or go back and get this and that. Even where, let me say, like a clerk of the judiciary could just has to sit down and most probably carrying out a search on another portal. They just don't want to do that. I know our worship has said that there's maybe lack of data, but some of these things actually can just be done in the most simplified way to make it actually much easier for like a practitioner to, so that you don't have to deal with a lot of back and forth, go back to idea, present like hard copy evidence in this day and age. Imagine you've received instructions where either trademark, copyright, everything is in a digital form, but then you're presented with a situation where you have the judge or the court system is requesting for physical, physical copies. It becomes definitely a little bit difficult to deal in that situation. And also another thing, one of the biggest challenges definitely we experience is lack of specialized cost. I think all the other panelists talked about it. That poses one of the biggest challenges, because the chances of appearing before a judge who has no idea what digital, copyrights are becomes very difficult. It means that you're going to have more adjournments in this case to make that the judge even try to understand, or if the magistrate to understand what you're talking about. There's the lack of connectivity alone from, let me say, URSB URSB and a code NITA, because if we had like one system where you're able, by a click of a button, to understand at what point was this copyright registered, who registered it first, and was it registered at a regional level, meaning Africa, or international level? If all that is available to us as lawyers by a click of a button, definitely to make work much easier. But imagine in court with a judge or a magistrate who pretty much does not even understand what digital rights are, and then after explaining all that, then you have to deal with the system that is not connected at all. Becomes also really, it also actually, what I've realized, it creates a lot of backlog, because it means it's going to take a much longer time for a case like that to come to its conclusion. So what would we do actually? I think Her Lordship talked about that, and also believe, no, not Miriam. It was His Lordship about skill training. I think that has to be possible on both for us, the advocates and the bench. That I think is key to come up with specialized judicial officers who are able to really understand this field of law, especially in a world where we're in the world of in the digital era we're in. The other thing I actually wanted to talk about was more of this is something one of the areas I highly specialize in, which is the cybersecurity or cyber attacks that Her Lordship talked about. And personally, I think that it would be key if I personally think that it would be key for the judiciary to bring on board other like specialized specialized professionals to work together with the judiciary. Like, for example, cybersecurity professionals to help with what they call it, managing systems. Of course, this would be court systems, but also making them to understand how easily cyber attacks can be either dealt with, and how also like the kind of vulnerabilities these kind of copyright owners face in this day and age. I find that kind of collaboration with other professionals, bringing them on board and working together, that is of course judicial officers and other professionals, would definitely help us to, to deal with this major problem we are having right now, which so many people I think are underestimating, which in this age. I think I would stop at that and hear if there are any questions.
Thank you very much, Alice. That was well covered. So after listening to the judiciary side, the regulators side, and an experience from a fellow lawyer, I'm going to share some experiences from Tanzania and Zanzibar, perhaps. So if I may request the slides to be played on. So while they are playing the slides, I would start by saying that in Tanzania and Zanzibar, we have quite a lot of regulations and laws that are set up. But of course, the Constitution also under Article 24 allows you to own intellectual property or property. And we normally follow quite a lot the trade and service marks, plus the copyrights and neighboring rights as well, which are very similar to Uganda, I believe. But Zanzibar, on the contrary, normally use the Zanzibar Industrial Property Act and the Zanzibar Industrial Property Regulations. We have a few agencies that govern or regulate intellectual property, I would say.